Carrying on with this medical evidence. 47. In January 2021, a forensic treatment plan was formalised, which included monthly meetings with his psychiatric case manager in the correctional centre, a 6-weekly meeting with his treating psychiatrist, a requirement to accept treatment and medication as prescribed, and to provide regular urine drug screening samples and to comply with necessary blood tests to provide for metabolic and clozapine level monitoring. Definition: metabolic, adjective, metabolic, relating to or deriving from the metabolism of a living organism, a metabolic disorder. 48. The last review available in the evidence tendered where the defendant was actually interviewed and assessed was 22 June 2021 by a CMO, Dr. Andrew White, who noted, open quote, "Today he presents as somewhat dishevelled, but was woken from sleep to see me. He was pleasant and polite and cooperated with the interview. He said that he no longer believes the things about the Australian government or other conspiracies that he previously did. He admits to becoming completely preoccupied with these beliefs and that they had taken over his life and damaged his relationships. He attributes his change in mental state to the shock of incarceration and his wife ending their relationship, and does not think that the medication has helped in any way. Medication makes him dumbed down and tired, but he feels better on his current regime than he did when he was on more RX. Accepts his diagnosis and was able to label it as delusional disorder. Accepts that he was completely overrun by his conspiracy beliefs and accepts the label of delusional. Denied any ongoing interest in pursuing his conspiracy theories. His plans on release are to go back to work and attempt to reconcile with his wife. Said that family is the most important thing and he wants to do the right thing by his family. Will continue to take RX because he knows he has to, and police and PMP will require him to take it. Also admitting to smoking THC prior to custody. He won't do that anymore because he doesn't want to go back to it, and he is also aware of parole conditions. Plans to go back to live with his ex and kids, boys in their 20s. IMP. Implied delusional disorder seems most likely diagnosis probably on B/G of narcissistic/paranoid PD and THC use. So do you fit inside their box? Because that's what this is. We've had at this time a year of incarceration. We've had 12 months of being drugged. We have an interview with the Dr. White where the patient is admitting that this is not helping him. This is the forensic mental health inside New South Wales jail systems. This is a large evil that the New South Wales government will not address. And given that the United Nations have knocked on their door, and given that they have taken these actions very specifically against a very specific belief, an attempt to brainwash that person from believing certain things, demonstrates a modus operandi of the state itself, at which these police officers know they have an upper hand when they can induce this kind of reaction from their very own actions. Right, moving on. A summary of the positions taken by the parties regarding the statutory preconditions. So the police and the state have tried to enact a further monitoring and drugging of someone that should never have been drugged in the first place on their eventual leaving of the jail system. A summary of the positions taken by the parties regarding the statutory preconditions. 1. The plaintiff. 49. The plaintiff argued that the requirement of Section 27A of the Act are met given the defendant's current sentence of imprisonment is due to expire on 29 July 2021, and the sentence of the imprisonment was imposed for a New South Wales indictable offence, the firearms offence arising from the gel blaster gun found at his home. The indictable offence was the searched for offence, wasn't it, Matthew Reason? And the moment you found a toy gun, you went over and above where Section 109 of the Constitution could be brought into play, in that these laws exist in other states that make those toys legal. Does the state have the right to legislate over the people? There is a good question in that in itself. Who is the state? But this problem arises from a toy gun. This is not a real gun. This is not a gun that any terrorist organisation would employ in a terrorist type activity, Matthew Reason. And you full well know this. 50. The plaintiff submitted that the court would be satisfied that the requirement of Section 27B have been met because the matters alleged in the supporting documentation would, if proved, justify the making of an ESO. If proved, it was emphasised that the court must take the allegations and documentation at its highest, and it is not for the court at this stage to weigh up documents or resolve any conflicts or inconsistencies which appear in the documentation, nor to predict the ultimate result or consider what evidence the defendant might present at final hearing. 51. The defendant is a, quote, convicted New South Wales terrorism activity offender, close quote. Having regard to the definition of that term in SS 10I and 10(1)A of the Act, because he has previously made a statement advocating support for violent extremism or has previously had personal or other affiliation with a group or organisation that is or was advocating support for violent extremism, Section 10(I)(c) of the Act. we already know that this was shot down in a ball of flames. But the fact that the plaintiff has used the term convicted New South Wales terrorism activity offender when this is not specifically and actually true is a discolouring of the law instead of the spirit of the law. It's not even the letter of the law. 52. Having regard to the broad meaning of, quote, violent extremism, end quote, that captures conduct that might not satisfy the technical definition of a, quote, terrorism act, end quote, particularly matters were identified, said to be evidenced in the documentation supporting the plaintiff's application, which would, if proved, amount to advocating support for violent extremism for the purposes of Section 10IC of the Act. So we'll go into these bullet points in the next episode. But we can see that there's a direct attack here. And it's there for a reason, and the language that's being used is specific in its purpose. But it doesn't detract from the fact that there are those international humanitarian laws on the table, and there is somewhat an obligation at a federal level, which is why there is such a diplomatic incident with relation to the United Nations being denied access to New South Wales facilities.